Good morning and welcome to St Philip's Employment's latest webinar in our COVID collection series. With rates of redundancies on the rise and furlough no longer an option to enable pressing economic issues to be kicked into the long grass, and of course with redundancies being one of the topics that is on the table in the context of the current rail strike issues, I'm hoping that today's webinar will provide a very useful and practical insight into dealing with the legal issues that surround redundancies and reorganisations in the workplace in connection with COVID. So it's my pleasure to introduce our two speakers today, Wendy Miller and Francis Morton. Both of these are tried and experienced in the tribunal process, able to deal with complex and high stakes litigation. They both have worked for solicitors' firms prior to working for St Philip's. So I think I can safely say that not only can they speak to us as specialists from a practical point of view, but also they can speak with an understanding of what are the needs of our professional clients. The format of today's presentation is that in a moment I'm going to hand over to Wendy, and then we'll hear from Wendy and Francis. There will be on your app a Q&A function. What I'd like, please, is if you have questions either now or during the course of the session to enter those Q's into the Q&A, and I shall manage those and I will collect them and I will put to our speakers, or indeed the relevant questions or the key questions that you've raised with me at the end of their presentation. So feel free to use the Q&A function. And finally, I plan to upload a link to a survey in the chat function on the app at the end of the session. And I would be very grateful if you could take a moment to complete that. It helps us enormously, not just to understand how we can improve, but how we can offer you the most topical top subjects in future presentations. So without further ado, I'm going to hand over to Wendy.
Thank you very much for the introduction. Good morning, everybody, and thank you for joining us today. I'd just like to go through the agenda first, just to give you an overview of what the talk is really going to focus on. So first of all is going to be the introduction, which will go through a few statistics referring to COVID and the pandemic and typical problems. Then how to identify a genuine redundancy situation for collective and individual consultation, how to identify a reorganisation, and then what practical advice will assist you. So I'm now going to hand you over to Francis, who will go through a few of the first slides and look at the overview of the pandemic statistics.
Thank you, Wendy. Good morning, everybody. At the beginning of all of this, it's important to note that redundancies and reorganisations, nothing's changing because of COVID. But what we can now see, and what I've seen, and I'm sure many of you have seen, is that you'll be now receiving a number of claims or defending a number of claims that specifically deal with redundancies arising from the pandemic. Now, what we can see in this first slide is effectively the pretext for this problem. What you can see here is you can see the massive increase that there was in the 3-month periods for redundancy. So particularly, you can see that in the 3 months going to October 20, or the end of October 20, when the job retention scheme was initially meant to close, we can see that enormous uptick. And by 2021, December to February, at the end of the slide on the right-hand side, you can see that things have pretty much returned to pre-pandemic levels. Now, it's worth noting that this slide, it only covers the 2020-2021 area, but the peak of this is even higher than the financial crash that we saw in 2008-2009. Now, you can't see the numbers as clearly on the graph, but you can see them here. And what we've done is we've highlighted the massive uptick that you can see from July to December in the sheer number of employees being made redundant during that period. you can see that we peak at 14.5 employees in every 1,000 in October. That's a massive number. And you can see as well, all of these statistics, they're all available from the ONS website. So if you ever need to look at them, they're all there. But what we can see is redundancies rose to 370,000 in the 3 months to October 2020. Employment levels falling by approximately 925,000 employees to one of the highest unemployment rates that the country has seen, full stop. So the problem that we have, well, the problem that we are dealing with on behalf of our clients now is dealing with the fallout from these redundancy processes. Now that can involve various more straightforward claims such as unfair dismissal, but it can go all the way up to massive collective actions, class actions involving collective consultation processes where those processes have not been followed correctly. And what many of you will have seen is, particularly those of you that service larger clients, larger corporates, is that a number of businesses, they took the opportunity with the backdrop of COVID to effectively reorganize their businesses. That resulted in redundancies, but in some cases, those redundancies, they weren't genuine redundancies. And that could be for a multitude of reasons. But the purpose of our talk today is help guide you through that minefield and advise your clients accordingly. Because there are issues that arise when you incorrectly label something as a redundancy or as a reorganisation. And this goes more than unfair dismissal. There's various risks with discrimination, with whistleblowing. It covers the full plethora, really, of employment law. And what you can see here is that the overarching theme of the pandemic has been that COVID isn't simply the answer for an employer trying to justify an exercise like this. It varies massively by sector. Now, what you have here is a table that's taken from that report that was referred to in the previous slide. And what this shows effectively is that not all sectors reacted in the same way. You have some sectors which were massively impacted by the pandemic. And in those cases, clearly redundancy exercises were not only necessary, but vital to avoid closure of business. In particular, I'm referring to, as we all know, the hospitality industry was dead for a long time, with hotels being closed, restaurants being closed. But then on the flip side, you have other areas that have actually seen an increase in economic output. Now, with that in mind, we're going to look at the typical problems that you'll face. Looking at that, I'm going to cover the first 2 points, and Wendy is going to cover the second 2. The first being that employers may well use redundancy as the reason for dismissal in these large collective exercises or in smaller exercises when they want to remove certain individuals. Now, this is something that claimants will, those of you that advise claimants will often have to deal with, and those advising respondents. Masking redundancy as the real reason for dismissal is not something new that's arising out of the pandemic, but it's certainly something that's going to come to the fore because of this. And we've had, in our previous talks on the COVID collection, we've discussed other issues such as health and safety grounds for dismissal, which Paul Wilson did, or the talk that Julie Duane, Colin Barron and Sheva Nilagrante did on dealing with other issues relating to that. The second issue is employers wanting to avoid paying redundancy payments when they're actually payable. So the right to a statutory redundancy payment, of course, that's enshrined in the legislation, but there has to be a genuine redundancy situation for that to arise. So there are cases where employers, they may not want to pay that amount, may not be that they can't, that's a possibility, but there's also an equal possibility that they simply don't want to. And that also has inherent links with age discrimination, whereby reorganizations, or they're branded as reorganizations, may be carried out in such a way that will disparately impact all their employees. One, on the basis that they may have more favourable terms and conditions, which Wendy will no doubt allude to in the fire and rehire point, or secondly, simply the amount of the redundancy payment award, because it's linked to length of service. So those are the first two issues, and Wendy's now going to speak to you about the second two issues on the slide.
Thank you, Francis. I will just a point on the figures that you've referred to and presented so thoroughly. It's quite clear that the COVID crisis has forced many businesses into financial pressure to make difficult decisions, either contemplating on downsizing or ceasing business activity. And very often in those situations, redundancy is unavoidable. But this is why it's now important to differentiate between the restructuring exercise and the redundancy exercise, specifically for these reasons that are set out in the typical problems slide that you can see here, because there's a very fine line between them. And as Francis has just alluded to, within this slide, he has identified recurring issues that keep coming up time and time again for both him and I'm sure yourselves, as you've been going through the new claims that are now coming through from the pandemic, that employers are masking redundancy as the real reason for dismissal, where a company wants to make someone redundant that they feel doesn't fit the business model anymore, and they give COVID as a reason for dismissing that person. Or another issue that has arisen where employers want to avoid heavy redundancy payments and discriminate against the older workforce, as Francis has just alluded to. So there may be situations already that you've come across where employers are opting for the label of restructuring so that they avoid going through the procedural safeguards of redundancy, which is the third entry on this slide. And then there's the classic scenario where a company will try and change an employee's terms and conditions to accommodate the change in the business structure. And an employee might have consented to that in the peak of COVID in order to save their job. But those that refuse to consent may then have been dismissed for some other substantial reason. And then the company then subsequently offer re-engagement on the new terms without demonstrating a sound business reason for changing the terms and conditions or following any consultation before dismissal. So these are real pertinent areas at the moment that are prevalent, particularly to the pandemic, and you will need to have focus looking at those sorts of cases. If we can just move on to the next slide, I'd like to deal a bit with redundancy and TLRCA, please. Firstly, looking at the larger scale redundancies and reorganisations, there remains considerable protection for employees either way. And Section 195 has a wide definition and doesn't purely focus on whether the employee is redundant in the same way that the narrower definition in the Employment's Rights Act does. The consultation process, or the collective consultation process, I should say, is a required stage where the employer gives a reasonable warning about the potential redundancy and provides the opportunity for objections to be made. And if the employer intends to make redundant more than 20 employees within 90 days or less, the consultation shall begin 30 days prior to the first dismissal taking effect. If the employer is proposing to dismiss 100 or more employees, then that process must commence at least 45 days before the first of the dismissals take place. So there must be an information in writing and consultation, and a meaningful consultation that includes a consultation about avoiding the dismissals, reducing the number of employees to be dismissed, and mitigating the consequences of dismissals. It isn't enough to say simply that this is due to COVID, and it has to be a meaningful process, looking at alternative employment, which must be covered, which must be offered to the employees affected before the expiry of the contract. If we can go on to the next slide. This now introduces section 139 of the Employment Rights Act, which I'm sure you are all very familiar with. And it doesn't really need further comment from me in respect of the wording of the section, but it really encompasses an employee who's dismissed for a reason of redundancy if the dismissal is attributable to the fact that his employer has ceased or intends to cease to carry on the business for the purposes for which he was employed or she was employed, to carry on the business in the place where the employee was. So employed the requirements of the business for employees to carry out that particular work, or in the place where the employee has now ceased or diminished. So then we really need to look at the reasons to cease trading, moving on to the next slide, which I'll now invite Francis to talk about the first 3 sections of that slide, and then I shall come back to deal with some practical tips.
Thank you very much, Wendy. Well, as Wendy identified there, you have a much narrower definition in the Employment Rights Act than you do for your larger collective consultation obligations. But looking then at that narrower definition in the Employment Rights Act, one of the main reasons which can justify a redundancy situation and identify that a genuine one does arise is where a business ceases trading. Now you see 3 points at the top there. The first point that I have to stress is that the employers, they don't have to justify a declaration of redundancies. The Employment Tribunal has said on numerous occasions that it won't evaluate the practical steps that are taken by a business that result in the redundancy. So they're not going to look at that. Doesn't matter, coronavirus or no. The second point at the top is where there's a closure of a business, so the full business closes, there is a genuine redundancy situation in those circumstances. And that means that statutory redundancy payments are generally going to be payable. One of the practical tips to deal with there, well, one of the consequences of that is that your employees, well, if you're advising claimants, there's always an issue, well, how can they get the money if the business is closing? Is it going into liquidation? Is it going to be completely gone? So in those circumstances, you do have recourse to the government fund in that respect. And that's something that we can look at, or we can advise you on if that sort of thing arises. The third point is the closure of the workplace. So the specific workplace, say you're working for, say you're advising a retailer, they're deciding to close a store, or you're advising a distributor of parcels, for example. You can immediately see where there's a closure of a site, then that could result in a genuine redundancy situation. Now, there's an important element to this in that it has to be, you can see in the first part of closure of workplace on the slides, it's got to be in the place where the employee was employed. Now, in the place doesn't mean where the contract says every time. For example, if my contract says I work in Leeds, but in reality I spend all my time at site in Birmingham, where do I actually work? Well, the genuine situation, which, as we know, particularly recently in employment law, it's all about looking at what the actual relationship is between employer and employee. The actual place where I work would in that circumstance clearly be Birmingham. So it's important that you identify that with your clients as well. Now, moving on from that, you have these elements to consider, but now we're going to talk, it's all well and good us telling you things that are in the Act, but Wendy's now going to move on to, well, what are some practical tips that you can take moving forward from this when you deal with a situation where an employer has started to cease trading or intends to cease trading?
Thank you, Francis. So as we've set out there, there's just a few points on practical tips that you might like to have as a kind of crib sheet as you're going through preparation of your cases. So when identifying the closure of a business, consider the following. Does the employee in question have a contract of employment that confirms the normal place of work? And if so, does that reflect the reality of the situation? And does the contract contain a valid and reasonable mobility clause? So that's what Francis was just referring to when considering someone's place of work. And it's important to obtain witness evidence early, as well as CCTV footage and materials that may be deleted over time. That's absolutely crucial when you are relying on evidence that can assist the case and undermine matters for the other party. And review and retain logbooks, work diaries, confirming the place of work, consulting with employees about the impending closure and ways to avoid it, keeping written records signed by employees to confirm the accuracy of those discussions. That's always vital when you come down to cross-examination, looking at written records actually signed as to their accuracy bears much more weight in a tribunal decision, and ensuring there's a paper trail of alternatives to redundancy being considered. So if we may just move on to the next slide. I'd like to talk a little bit about reduced requirements. So if we look at the first column there, less work for staff. This is when the business no longer needs as many employees to do the work or anticipates that being the reason. Clearly in that situation, you would be looking at a redundancy situation rather than a restructuring situation. Within the reduction in hours, of course, you'll all be very familiar, I'm sure, with the case of Pac-Man, which establishes less hours will be a redundancy situation. For example, someone that brings in IT software to replace man hours spent on a job. Effectively, the decision clarifies that any dismissal by reason of a downturn in work and consequent reduction in hours for a proportion of the workforce during which that work is performed, it can be a redundancy situation. And then if we move on to the type of work, this is also another area that you'll consider to decipher whether this is a redundancy or restructuring. And of course, the case of Murray is extremely helpful in this regard because it's given some direction on the fact that it demonstrates that it is a question of fact for the tribunal to determine the type of work of a particular kind and whether the requirement for that work has ceased or diminished. So that's something that you must very much focus on when considering work of a particular time, going back to the statistics that Francis presented earlier. I expect a lot of these claims will become relevant in the service and entertainment sectors now, but it's very crucial at the outset to define the type of work relied upon with clear parameters. We may just move on to the next slide. I think Francis is now going to deal with the reorganisations.
Yes, thank you, Wendy. Now, here is the difficult difference and something that needs to be distinguished. And that's what is the difference between a reorganisation and a redundancy? Because quite often the two will meld together. And we can see that on the right-hand side, you've got a quote from Robinson and British Island Airways Limited, which was approved by the Court of Appeal in the more recent decision of Shawcat and Nottingham City Hospital, which is it may or may not end in redundancy. So how does that help you? Well, the purpose of this talk is that we identify the differences to enable you to do that. With reorganisations then, every case is still assessed against Section 139. And it's important to identify that it doesn't matter what label your client is putting on this. It doesn't matter if it's a new deal. It doesn't matter if it's a restructuring. It doesn't matter if we're changing the face of how we work. All of these assessments, they still come against the same statutory instruments. Now, what indicates that there may well be a redundancy situation? Well, the first is where there is an actual reduction in the number of employees. Now, that doesn't mean that it will always be the case, but it's more likely that the tribunal is going to find that there was a genuine redundancy situation. So from the Robinson case, where you have the quote on the right-hand side, you can see in that situation, there was work done by two individuals, a flight operations manager and a general operations manager. That was absorbed into a single new post of general manager operations and traffic. Now that's held to be a redundancy situation. Well, let's think, well, why is it held to be a redundancy situation? Well, there you have two posts, a particular kind of work. Clearly there's less work in that business because effectively two people, their job became one. And what that means is that there wasn't enough work for both of them, and there was a reduction in the number of employees to reflect that. So they combined the type of work, which was clearly intermingled. And in that case, you have more likely than not a genuine redundancy situation. And you also have the decision in Carry On Motors and Pennington, which is referred to below on the same slide, in which the Employment Appeal Tribunal, they reached a similar outcome. Pennington was a transport clerk at the Bridlington depot, responsible to the depot manager. The company's accountant considered the depot was overstaffed, recommended that two posts be merged. You can see that the general idea here is that where you have similar type of work, but you don't have enough work for those individuals, that you may have where you have a reduction in number of staff, it's more likely than not that you're going to have a genuine redundancy situation. Now, put that against a reorganisation where you have effectively a relabeling or rebadging of roles, and only certain individuals have been handpicked or cherry-picked to exit the business. That goes back to masking the real reason of redundancy that we were talking about. But you can see in Pennington that the Employment Appeal Tribunal points out that although the output was the same, the company needed fewer employees to achieve it. And that's a redundancy situation. Moving then to continue looking at, well, what are the differences? What are the things that will help guide you in advising your clients? Is conversely, where there's no reduction in staff, you may well have a different scenario. You can see on the left-hand side of the slide that this refers to the case of Shawcat, which approved the decision that I've just been speaking about. And in that case, quite unique facts. Claimant was employed as a thoracic surgeon, hospital built as a cardiac unit, wanted him to combine pure thoracic work with cardiac work. He refused, they insisted, he resigned and successfully claimed unfair constructive dismissal. So this went all the way to the Court of Appeal, and they held that the tribunal was correct to find that purely thoracic work was a different kind from combined thoracic and cardiac work. That goes back to what Wendy was talking about identifying the particular type of work and whether there was a diminishment in that type of work. But the Court of Appeal held that the claimant wasn't redundant. There was no diminishment of that type of work. They still needed as many employees to do that thoracic work. And you can see, particularly at paragraph 16 of the judgment, that the reorganisation in question involved the trust arranging for more staff, not less, to do cardiac surgery. It didn't involve a corresponding reduction in the requirement for thoracic surgery. And it's that requirement, it's that diminishment of a particular type of work that's going to lead you to a redundancy situation rather than a reorganisation. The second point in the middle of the slide is that, as I was alluding to earlier, it's the substance of what's actually gone on. It's not the label that's attached to it. A rebadging job is not immediately going to say, well, this is a reorganisation, it's not a redundancy situation, so you're not entitled to redundancy pay. That's not simply going to cut it. It's not simply going to cut it if a business says in the course of coronavirus, we're giving you all new job titles. Your job description and job role is all going to be the same, but we're now going to call you under a different name. But because of that, we've got to make cuts. It's not that simple. And you can see that in the middle of the slide, that if a role is simply repackaged, the type of work is the same, then this will not amount to a redundancy situation, providing there is, of course, no dismissal that goes with that. The same goes for cases where an employer affects a change in terms and conditions. And you've got the case of Safeway Stores and Borough, in which the Employment Appeal Tribunal held that if the requirement for employees to do work of a particular kind remains the same, there can be no dismissal by reason of redundancy, notwithstanding any unilateral variation to their contracts of employment. And finally, the third segment on the right-hand side, again, I've already spoken about this, but it's the requirements of the business. So redundancy situations, they may arise where an employer's requirements for a particular kind of work ceases or to diminish, or is expected to do so. Now that's the practical needs of the business. So as Wendy identified earlier in practical tips, you need to identify this with your clients. What was the reduction in the type of work? What evidence can you provide to the tribunal that there was a genuine reduction in the type of work that the claimant needed to do in the case? And the same goes for claimants, in that that's the way that you can really attack an argument, to say, well, where's the evidence? Moving on from that, we've now got, after having an overview of the law in this area and identifying some things that will sway more towards redundancy situations, some that will sway more towards reorganisations, we've identified some practical advice for you to take away from this seminar to assist you and your clients throughout the whole litigation process. Now, at the outset of this, before we begin with this practical advice, I will say we're not particularly identifying these are all the claims that you could bring, and this is how you defend particular types of claims. That could have its own collection series on its own. In fact, it would need it. But what we do have here is general guidance in relation to redundancies and reorganisations, where you have a litigation process that involves the typical problems that we identified earlier. And that involves all manner of claims, be it unfair dismissal, age discrimination, as I alluded to earlier, may come into it, various types of discrimination in connection with the pandemic. So you have discrimination arising, disability discrimination I'm seeing a lot of that in my own practice coming through recently in relation to redundancy exercises. But moving from that, Wendy's now going to go through, well, what should you do at the outset? So either one, claimant comes to you, former employee comes to you, or it lands on your desk because you're servicing a large client. So what are the steps that we say that you could take? So Wendy, I'll hand it over to you.
Thank you, Francis. Well, I'm sure I don't need to tell you all that you've got to obtain relevant documents. It's on the slide for completeness, but this is really having identified what the likely arguments are going to be, which is crucial in seeking your disclosure in terms of whether a redundancy situation has really arisen here, and reviewing the relevant documentation as to the sector that the respondent or claimant operated in at the time, and how this is impacted by the pandemic. And a helpful guide there is really going back to the statistics that Francis alluded to earlier. Looking at the sectors is also key in trying to ascertain redundancy situations. It provides supporting evidence. The nature of the inquiry will not look at the reasoning behind the redundancy, as we referred to earlier, but you determine whether the respondent have put in place a sham redundancy, and that is also key. Whilst they won't look at the reasoning behind redundancy, it's very relevant if something appears to be a sham redundancy, and you'll seek disclosure to establish that point. The most important thing that I've come across throughout claims is turning your mind to remedy and obtaining evidence as to mitigation, because quite often this will be forgotten during the process. All the focus will tend to be on the matters that I've referred to just in seeking disclosure and formulating the arguments and identifying the areas. But in the background, it's really important to be advising your clients, to be the respondents, to be looking at those areas of mitigation, jobs on the market at the time that could have been applied for, because this is often where we end up in situations where it's very difficult to argue against remedy unless that evidence is there. And also identifying with your client whether a genuine redundancy situation arose or whether this was a reorganisation. So as we've referred to, considering the number of employees affected, consider the type of work of the claimant and whether they were the only one impacted, and considering whether this was a case of efficiencies. So that's really a few points to deal with how you approach things at the outset.
Thank you, Wendy. I'm now going to talk to you a little bit about, well, pleadings. So top tips for pleadings. Now, Wendy's already alluded to identifying the issues, looking at the redundancy situation. Do you think it's a sham redundancy situation? Discuss this with your client. For both sides of the coin, it still works the same. But if you're going to challenge the redundancy situation, be specific in your pleadings. Say which element of section 139 you say, well, this hasn't been complied with. This is not the case. Or alternatively, if you're acting for respondent, identify exactly why: closure of the business, reduced requirements, overstaffing, issues like this. Focus on the factual situation here. Look at the redundancy situation rather than fixating on the contractual position. What actually happened in practice? Now that will help guide you, as well as looking at, well, have procedural safeguards been included? Was there a warning of impending redundancies, for example? Was there consultation in relation to those issues? Was suitable alternative? Did the employer look for suitable alternative employment? And it's important to remember that in respect of that latter point, that's a continuing obligation. I see it quite regularly where respondent has given claimant notice. Claimant is a long-standing employee who's been with the business for 12 plus years, has a long notice period, and yet no attempts are then thereafter made in relation to alternative employment. So that's something that you should turn your mind to as well. That's something that I do genuinely see quite often. So that's incumbent on the employer, that's a continuing obligation in those regards. So if there has been that failure as the claimant, plead it. Identify that no further steps were taken during this period when there was an obligation on the respondent to do so. They had to take those reasonable steps. By the same token, if your respondent, identify the meetings that took place, but don't simply say the respondent denies this, there were steps taken. No, in your pleadings, identify the jobs that were identified to the claimant. Identify the meetings that they tried to make with the claimant in order to look at alternative jobs. If there's email correspondence, because that's one thing that we'll come to, that no doubt Wendy's going to come on to when we look at disclosure. Quite often you may have disclosure and there'll be a file somewhere for an employee that's in the back cupboard of a distribution center or a retail store or who knows where. But there's often email correspondence that's missed out from that happens between management and the employee looking for those roles. So identify all of that in your pleadings. Identify the strongest position possible, because that's the first thing that the tribunal is going to read. The third bullet point, set out any process that was followed. That largely goes with what I've just said. But identify issues with that process, or strengthen your position by saying, this is the full and complete process that was followed. Warning, warning of impending redundancies, notification of consultation, the fact that consultation meetings were held. All of this is going to assist you in identifying, well, not only was there a genuine redundancy situation, and that's because from a respondent's perspective, we followed all the procedural safeguards to suggest it was a genuine redundancy situation as well, because within those documents, those consultation documents, you're probably going to identify, that's going to assist you in identifying, well, was it a sham or not? And then that also takes you, in the cases of unfair dismissal, to the next stage of the process, well, where there's no burden on, where the burden's neutral for either side. Well, was it a fair process as well? And the final point, and the clearest indication of there being a genuine redundancy situation is, well, is there a causal link? You need to identify that causal link. It's not enough, particularly in cases of discrimination, for example, even showing less favourable treatment in the case of a direct discrimination claim, that's not going to cut it. The claimant in those cases has to go further than identifying merely less favourable treatment, but actually there needs to be something that suggests, well, it was because of a particular protected characteristic. And the same goes with identifying there's a clear causal link between a diminishment of a type of work and there being a dismissal. So moving from that then, with that in mind, and your pleadings in order, Wendy's going to talk to you about another crucial point of the tribunal process and things that you can do in this situation going through disclosure.
Thank you, Francis. Well, disclosure is something that is absolutely imperative in claims for them to have maintain the case for the respondents or claimants. There's nothing worse when you arrive at the tribunal and the claimant raises something that's the document that should have been disclosed and hasn't been disclosed, and then you end up adjourning overnight for that to be disclosed, and then suddenly your case is starting to lose credibility. So disclosure is really key, and it's something that I know other barristers at St Philip's really focus on in terms of progressing the advocacy part of the tribunal process and bringing the claim to fruition once the final hearing starts. So firstly, don't solely rely on standard disclosure. Always be specific in what your requests are so that you can always rely on the fact that they've been requested previously and not disclosed if they suddenly are flagged up during the final hearing. When acting for the respondent, don't simply accept the disclosure you're provided with. Always review the documentation and ask for more if required. So really, as you know, the burden is on the respondent to establish that a redundancy situation has existed, and it's for you to discharge that there was a redundancy of some kind. So you've got to really focus the disclosure around that element and make sure that the focus has looked at the practical consequences of the reduction, if that's what's being relied on, and if pleading mitigation of loss provide the evidence. And finally, when acting for the claimant, particularly when pursuing claims that intimate difference of treatment, always request documentation in relation to your client's team or other individuals, such as scoring and selection criteria that may have been redacted by the respondents, because that is absolutely crucial in considering whether it's been a fair process, clearly, and therefore is disclosable and very relevant.
Thank you, Andy. I think that's an excellent summary of what you need in disclosure, particularly on the last point, not only in relation to the fairness of the process, but also with this difference of treatment, where there's discrimination being alleged, for example, and employees are not given the full picture of selection criteria and scoring, particularly scoring, because selection criteria, in my experience, is usually dealt with across the board, but the scoring of the individuals or how that decision sort of has been reached, that's something that quite often becomes a genuine issue. And I also point out, I'd also say the top point on not only relying on standard disclosure, but I genuinely think that is something that's very underutilized in the tribunal process. there's not that many, I don't come across that many applications for specific disclosure, and you won't always get the smoking gun you're looking for. But I recently had a case where I was looking at a dismissal letter in relation to a dismissing officer. He referred to correspondence that he had with the individual who's carried out the scoring and selection process. And there was no trace of this correspondence or these meetings that happened. And we made a specific disclosure application in relation to by the way, those applications, they should be precise. You can't go on a fishing expedition, but if you look at it and say, right, we want these specific emails that we know were carried out in relation to that incident. In that case, we had, it transpired in the correspondence that one of the reasons was because the individual I was representing, one of the key considerations is that she was relatively young, had recently had a child, been on maternity leave for 12 months, and they were fearful she was going to go on maternity leave again. So you're not always going to get that smoking gun, but clearly that resulted, that was the smoking gun for a pregnancy maternity discrimination case. And moving on from that then, witness statements, one of the most time expensive parts of the tribunal process, if not the most, as you'll all be well aware, and the most costly for clients as well. So it's important that you cover all the basis for what you need in these statements. Now, with that, we've already said that it's about the practical consequences of the situation. Identify those practical consequences with references to the documentation that Wendy referred you to previously. Those, if you're challenging redundancy, if you're challenging the type of, or a reorganisation, for example, saying one is, whether it's one or the other, look at where there's that diminishment of work and identify that in your statement. Refer to documents such as accounts, for example, or output for particular types of work versus the amount of work coming in. Going back then to coronavirus and the pandemic, and what we clearly have is this massive influx of redundancies, which you saw at the beginning of this talk, is that if the dismissal does rely heavily on the pandemic, look at the sector-specific materials that are readily available online as well. That's always, they're readily available online. Again, we identified earlier, the tribunal's not going to look at the reasons, what's caused the employer to say, right, we're going to make redundancies. They're going to look at the genuineness of that redundancy situation. But that does provide helpful context as well. And if the employer is simply saying, well, couldn't do it, COVID, it's simply not going to be good enough, is it? Now, I think that what Wendy said earlier is essential in that remedy is a key issue here. And remedy is often underlooked in witness statements. Those sector-specific materials, in my view, are particularly helpful for your clients working either way in relation to remedy. The number one thing that comes to my mind is mitigation of loss. For example, if I'm acting for claimant was dismissed, say, in May 2020, he or she works in hospitality or entertainment. The reality is they couldn't mitigate their loss for an extended period of time. So if you're acting for respondent, that's going to be quite difficult to come across. But acting for claimant, make use of that. And by the same token, if you've got a sector-specific industry that actually saw an increase, for example, look at Amazon, or look at distribution, delivery driver jobs, or long haulage vehicles, where we've seen a massive uptake following Brexit. All of these industries, it's sector specific. So with that in mind, we'd now like to open up the floor to questions.
Super, thank you very much, Wendy. Thank you very much, Francis. That's been a very engaging talk and hopefully a great assistance to us in the front line of dealing with these matters. I'm also going to introduce Bruce, who's going to come in on the screen too. He's one of our colleagues in Chambers who's been sitting in and listening in to Francis and Wendy's presentation. But first, Francis, I have a question for you, which I think is a really good question, bearing in mind the title of the topic today. The question is this: if you're focusing on the pandemic and dismissals that are made in response to the pandemic, what aspect of tribunal work are you seeing, or do you think are most likely to be affected?
That is a good question. I think I've already alluded to this quite recently, but for me, it's going to be more about remedy. And the reason it's more about remedy is because we can see that the statutes and the interpretation of that, that's not changed. What you will have seen through the slides is the majority of these decisions, these authorities, although they have been endorsed in more recent case law, a lot of them are from the late 90s, early 2000s. So the way in which tribunals approach this isn't going to change because of the pandemic. But what it really is going to relate to, in my view, certainly, is remedy issues. I touched on mitigation of loss, that being the clear one. Well, claimants, they have a duty to mitigate their losses following a dismissal. They can't just wait for the payout from the tribunal, even if there's been an absolute sham of a process. And what we did see, though, is I think that that certainly provides arguments for both sides, for claimants and respondents, based on sector-specific materials. You saw from the graph what a massive difference there is sector to sector. So mitigation of loss is certainly one. By the same token, though, I don't think that's going to give claimants carte blanche in order to say, well, because of coronavirus, I couldn't work and that was it for the next 2 years. And that's because we saw in the graph that redundancy levels have now dropped to pre-pandemic levels as of late 2021. So arguably, the market has picked up massively in those areas. Now, unfortunately, despite the best efforts of tribunal staff, we have a massive backlog in the tribunals. I'm seeing, I don't know about you two or you, Wendy, but I'm seeing cases now to do with dismissals that occurred in 2019, early 2020. Yeah. So that makes the relevance of this talk particularly poignant, regardless of the rail strikes, which we all know about. But this is going to become more and more of an issue. And for me, there seems to be a sector-specific view on all of this, certainly from the information that I've seen. But overall, in summary to your question, I think remedy is the key point in this. And it's important that everybody, advising respondents or claimant, turns their minds to remedy at the outset. Because as Wendy said, everybody fixates on liability. It usually forms the bulk of a hearing. Everybody wants to know, well, is it going to win? Is it going to lose? But the remedy is equally important, because if you're negotiating settlements, that's what you need to be thinking of. You need to be thinking, well, what can my client reasonably achieve? Or if I'm acting for a respondent, well, what is a good deal for them? What are they going to take? How are they going to feel at this? You need to be pragmatic with it. That's my view.
That's really, really helpful. Sticking with the pandemic theme, I think this may have been implicit part of your answer. Do you think that the tribunals are going to be more sympathetic to an employer's argument that they have a redundancy situation on their hands?
I think they are, but I don't think that it's. I think that if a tribunal were to stray into, too sympathetic territory there, I think that they'd be at risk, really, of an appeal against them, because
I suppose also it's the fact that tribunals don't second guess the employer's assertion,
no,
if genuine, of the fact of a redundancy situation. So.
Yeah, absolutely. But as well, there's not. As we know, the presumption that there was a genuine redundancy situation, that's disapplied in cases where dismissal is being considered. Well, is there an ulterior motive?
The cases I'm seeing more and more are sham cases, where it's like if you have a cheeky transfer situation, human nature often takes over, and you use the opportunity to shave off employees that you don't want, as opposed to those who are genuinely at risk of redundancy. So there's a cherry picking exercise. Redundancy is susceptible to that, as are other areas like Chupi, for example. So shams coming up. Now, if I could just pick up on the remedy element, I completely agree with you. That's my starting point. But what I've come across is a case that's only been published earlier this month. And that's on the point, when I'm advising on redundancy, the general advice is the A-class uplift doesn't apply, does it? Yeah. And there's a moment of caution here to both employee and employer representatives. Because the case that I've had a look at is Rent Plus and Coulson, only published at the beginning of the month, 8th of June. And what that identified is it does in a sham situation. And rationally, that makes sense, doesn't it? Because it's not a redundancy situation, but another reason for it. And on that basis, the ACAS
Comes back in.
uplift does, yes. So when advising on it, make sure that we all take that into consideration where we're dealing with the sham.
That's an excellent point. One thing I'd say as well is that where you have ulterior motive cases, sham redundancy cases, you often will find there is a grievance involved as well. So the ACAS code can also come into it in that perspective as well. Don't discount it. Don't discount the relevance of it simply because, oh, this is a redundancy situation. Despite the case, the authority you just referred to, there's also that element of it as well, because I actually do see it in schedules of loss that I receive. And I said, well, we could have a look at this. There's a grievance process here that's been just, bundled under the rug, so to speak, and nothing's been dealt with it. In the most blatant of cases, it's a simple, well, no, you've been dismissed, so we're not considering your grievance. Even in many cases, even if employee raises grievance during their notice period, at which time employer is still absolutely bound to consider it.
Good. Okay, now let's move on to a specific. I was intrigued by your slide on looking at what makes a redundancy situation. You talked about reduction in hours, and that case of Pacman was under topic. And I was wondering about how that might be formed. Here's a question, getting into the nitty-gritty from one of our attendees. When is the tipping point? When do you get a redundancy situation where there is a reduction in hours? An example given, we always like the absurd examples to test the point. What if you had a 5 hours per week reduction in hours? How do we assess at what point there's a tipping point and you have a redundancy situation?
It's a good question. I think that you have to look at all the facts of the case. There isn't a one size fits all answer, unfortunately. Your scenario, is there a 5 hour reduction? Is that to a 20-hour per week job? Or is it to a standard 35 hours per week sort of 9 to 5 situation? I think that it depends. In terms of reduction in hours, I think that if you're reducing hours anyway, you're already in the terms of you're unilaterally varying, aren't you?
I think it's a redundancy situation, and the true answer lies in the consultation process, where you offer in a potentially redundant position on the basis of a mild reduction, say 5 hours, as in the example. You consult on it, and somebody can put forward suggestions that I take that reduction, for example, and that's where the reasonableness element of a dismissal will kick in, not the question of whether or not there's a redundancy situation.
So you've basically treated it as a redundancy situation. Well, it meets the section 139 test of reduction in requirements. So, all right, let's look at, here's a question specifically on consultation. Can you give notice during the consultation if you think the consultation has effectively ended? It's perhaps served its purpose, provided the notice doesn't expire before the end of the consultation period. I think that probably goes back to understanding the purpose of the consultation. In other words, I don't know how you feel. If that question, does that presuppose that you think the consultation has come to an end? And has the sufficient period of time elapsed up to that point? Presumably that's the...
I completely agree. There's no one size fits all, is there? You've got to, and if you're the employer, and that's obviously a question from the employer side, just give as much leeway as you possibly can, because it's that type of thing that can snowball into an unfair. It certainly does, undoubtedly.
It snowballs as well into you've predetermined the decision, so meaningful consultation is not going to take place, argument from the claimant as well. And then immediately as well, you can bring in various strands of, particularly in those situations, we've said no one size fits all, but I'd say the important thing though in that situation would be consistency of treatment amongst the staff. Because otherwise, if you have certain employees who are being told at the beginning of consultation, for example, you're being put on notice, consultation process is going to continue, but your termination date is X, But then you have a different category of employee, for example, who is being told, oh, we're going to go through 2 or 3 consultation meetings and then we'll make a decision on your employment. There straight away, you have various arguments. And for particularly if it's a more difficult employee or somebody that's raised issues in the past, then all of that is likely to get dredged up as well. So I think Bruce is correct. You've got to give as much leeway as possible if you're going to adopt that. In my view, it would be better to at least have 1 consultation meeting before you decide, right, we're pulling the trigger, here's notice. That's my personal view. I think that gives you a much better leg to stand on when it comes to the question of fairness.
The question had the phrase effectively ended in it, and that could well be a subjective view that you think it's come to an end when it really hasn't. Just enough time, I think, for a couple of questions. I'm going to like the second question I'm going to put to you. I'm going to do it second because I'm going to give you a limited amount of time to answer it. It could take forever. The first question, when dealing with alternatives to redundancy, how much emphasis would a tribunal focus on the possibility of being able to furlough staff? I mean, this is now, as clearly as you said, it's becoming more topical because we're in final hearings now in relation to things that were happening in spring of 2020. So furloughing staff was a very real alternative to redundancy. Is it relevant?
It is relevant in my view. It's absolutely relevant because it's absolutely relevant. And there is the name escapes me of the case, but there was a decision, wasn't there? A first instance decision in which they said, oh, well, the failure to consider furlough as an opportunity wasn't fair in the circumstances because it was still open. And I think that that's something that's genuinely going to come into play here because we see a massive influx of redundancies ending in the 3 months October to 20. The scheme was then reignited. We know it was due to end, but then the government decided to extend it. Why then should an employer say, for example, employee is dismissed, given notice, dismissed on 31st October 20.
It ought to be a consideration.
Absolutely. Employee appeals decision. Why shouldn't furlough be considered? In my view, because it's not just the decision to dismiss, it's the appeal process as well, because it forms part of the overall decision.
Super. Final question.
May I just interpose that case that you've just referred to, Francis, I believe is Mindwara and Living Angels Care Limited, if that rings any bells.
It does. Thank you.
And it was about the decision regarded a live-in care provider who was made redundant by her employer in June 2020. And her employer refused her request to be furloughed as an alternative to redundancy because they said there was no work available for her. And the employment tribunal said that she was unfairly dismissed because a reasonable employer would have considered furlough as an alternative to redundancy. So I hope that helps.
It does, Wendy.
Yes,
you may have a view on this, Wendy, as well, or Francis and Bruce. This is the question, just a few seconds to answer this. It could take us an hour. It's a fascinating question.
Okay.
Is an interview process a fair way of selecting for redundancy rather than the traditional scoring matrix?
Well, I would say it depends on your workforce. And if I've had this before where people have had disabilities and that they wouldn't have dealt with an interview scenario particularly well. And it was suggested that an alternative to the interview scenario should have taken place and it hadn't. And so that was deemed to have been an unfair part of the process because an alternative way of the selection process was not put forward. That's something to consider.
That raises questions as well of section 15 discrimination and reasonable adjustments as well.
So is the answer it can be, but be cautious.
Yeah.
Yes, absolutely. Yeah. My answer is, in one word, is the word objective. Isn't it?
But that's the core of the redundancy process.
The risk of an interview not being properly objective is greater than the risk of a factual matrix. But both have risk because you could have a matrix of, giving a score of 1 to 10 as to whether he fits in. We know that's not an objective criteria. So that's, I think, more risky, but it can be effective in the right
do it. Yeah.
It can be done, but be alive to it, particularly issues like what Wendy has just identified.
Ed, I'm sensing that you're about to close it off. Can I just give a cautionary note on
always the final word?
Strike like Colombo, just one more thing. Look at the case of White and HC1 Oval Limited if you're going to consider strikeout.
Yes.
Strikeout should be considered. Have a look at that. Be cautious. Be cautious. Don't rule it out, but be super cautious with it and go for a deposit order as well.
Good advice.
Thank you.
Bruce.
Thank you.
Francis, thank you so much indeed for a great presentation. Wendy, thank you very much indeed for presenting today. And thank you all for tuning in and taking part and listening and sending great questions in to us. Thank you very much. And I look forward to seeing you at the next webinar, hopefully sooner rather than later. Good morning to you all.
Good morning. Thank you, everybody.
Bye-bye.